in medical negligence as well as third-party claims. I've in-depth experience in debt collection, debt reviews, insolvency, and a myriad of other issues. My chief area of expertise is litigation, as well as mediation processes involved in litigation. And just for a brief overview, my topics today will be job hunting, as well as fielding questions regarding the oral exams for the boards, for those of you who have recently written and have received an oral exam. Thank you.
Thank you so much, Ian. So you all know me by now, hopefully. Nevertheless, the topics that I'm going to be touching on is obtaining a remark in respect of board exams. And also I'll be speaking about also the other topics that Council and Ian will be mentioning on. So why don't we get started? Ian, if you don't mind, I feel that the oral takes priority when it comes to board exams.
Okay, so I'm first and foremost, I'm going to briefly do with job hunting because it's a very black and white area. And these are skills which you need to sit with yourself and perfect yourself. It doesn't help us stand you for 20 minutes and preach and you do not do the homework on yourself. I can only give guidelines. So when job hunting, I'm just going to give you do's, don'ts, and pitfalls. Do's: do an appropriate CV, have a strong body of references, appropriate supporting qualifications. It's your degree, your ID, your academic transcripts, your high school senior certificate. Then also, very important, networking. When you go to court or when you go to arbitrations or whichever forum you are in, use the opportunity to network. Find out where everyone is working, see if that supports your area of law. Find out what they do. And this is the best way to find out what is available. Very few attorneys firms actually put out adverts, as they would rather recruit from sources who they know. And if you have a good reputation, you will be quickly cherry-picked out of the bunch. Make no mistake about that. Then also a very big important thing is be clear on what type of employment you are after. If you're going to specialize in litigation, go for it. If you're going to specialize in commercial contracts, head in that direction. Conveyancing, stick to those guidelines and to those types of firms. You're going to be a lot happier there, and you're going to have a lot less stress on yourself. Okay, then don't. Don't represent yourself ever. Don't misrepresent your skill set.
Mentoring for new CIs. They're doing it once every few weeks, like half an hour. So I want to see what it's like.
Well, wasn't that interesting? Okay, but I agree with Ian that you want to target those fields of interest that you have an interest in, as you're going to be working long hours, you're going to be doing difficult work, you're going to be attending to matters that are complicated and rather draining. So having a passion in certain areas will definitely assist in ensuring and sustaining your ability to perform when attending to articles or pupillage, as the case may be. Sorry, and I hope you don't mind me just having chopped in right there.
Not a problem. Then just to continue on the don'ts, as I said, don't misrepresent your qualifications, because this is directly linked to your character and your work ethic. Your work ethic cannot be understated or overstated. If you're only prepared to be there for 8 hours, you must be prepared in an interview to say you only want to work every day for 8 hours. This is also going to narrow down your search on what fields of law you want to apply yourself to. Whether you want to get out of law completely and become a legal advisor, that's your choice. But this comes down to your work ethic. If you want to walk into an office space and work your arse off for 8 hours a day and then go home, that's your choice. But you need to prepare to mold yourself to fit into that type of position. A major thing that you should always avoid: do not apply for positions which are beyond your capacity. Do not apply as an attorney to be a conveyancer if if you have not been admitted as a conveyancer. This is a misrepresentation of your skill set, your qualifications, of your work ethic, and it reflects extremely poorly. It also demonstrates that to a future or prospective employer that you did not take the 5 minutes to read the minimum requirements for a position. Big pitfall that I've often seen attorneys make is they launch blanket applications for work. They personalize a cover letter that it looks like a Christmas tree. It shouldn't be that way ever. And a major pitfall that I've seen time and again, arrogance is your enemy. If you walk into an interview, be confident. Overconfidence is arrogance. You will not get that position if you're arrogant. If you want to propose a mock interview with a fellow colleague or with someone whom you trust, which will not spill the beans that you're looking for a different position. This can be an older attorney or an attorney from a different firm. These are very useful because it prepares you for types of questions. And curveballs are thrown in mock interviews which are beyond understanding. To give an example, for the interview which I had for my first job, they asked me what type of kitchen appliance I would be had I been a kitchen appliance. And the answer is linked to your creativity, and it is then linked to your manner in which you process ideas and justify your answer. Very argumentative, very creative answers, and it allowed the crowd to be thinned out. These are all random things that come to the fore when job hunting. Okay, now board exams, orals. I spoke to a candidate attorney yesterday who has two orals lined up. And it actually came to my attention that a lot of the orals are being done via Zoom. I don't understand why. I personally have the opinion that an oral exam is a hell of a lot easier when it's done in person, but be that as it may. When preparing for an oral, if it's via Zoom, make sure you study long beforehand. Make sure you have a good connection, as well as a fully charged laptop to ensure that you do not get interrupted by load shedding. Load shedding will be your downfall if you're operating without a UPS. When dealing with questions from oral exams, ensure that you address the question correctly. Confirm with the examiner, this is the question and you want me to answer it in this manner, because answering your question is half the success of your oral exam. I speak from personal experience. I had 2 oral exams during my boards. When it comes to doing oral exams in person, I found it much easier to connect on a human level before I connected on the academic level with my examiners. By doing this, I attended the venue 2 to 3 hours in advance, and I ensured that I was studying every time one of the examiners came out to fetch the next candidate for their oral presentation. In doing this, I placed it in the minds of the examiners that I was going through my work and that I was a dedicated person and that I was prepared to answer whichever question may have been presented. On one oral exam, I answered a question in a very technical manner. So the examiner asked me to just give me a very simple answer on how to terminate a will. I went into very technical answers in terms of section this, section that, where he just wanted to have a simple answer of a revocation clause in a new will. Other exam was for civil procedure, and I ended up getting a constitutional law question related to summary judgment. That tested me quite well, but because I had sat there and studied and I was very polite with my hat in hands, I was able to pass my board exams without an issue. When preparing for board exams, make sure that you are calm, collect, that you've gone to the toilet before your allotted slot, and that you have a bottle of water or something nearby. If you need to, stop, pause, say to them, I just want to take a sip of water, pick up so that if it's on Zoom, they can see and have a sip of water. It is worthwhile just to get yourself calm. Thank you. Any questions can be put on the chat and we'll freely attend to them after the session. Thank you. Bruce, your turn.
Thank you, Ian. I can't agree more with you regarding the orals. That also something I picked up is that dress code. It is actually a thing that you dress for success. Not only are you priming yourself from a psychological perspective, you're also priming the people who are interviewing you and considering you for your oral, because you walk in with a presumption that you have failed the exam. So you dress for success, you come across as confident, not necessarily arrogant, and you demonstrate an understanding of the material. Also, I've picked up that some of the examiners are very happy when they see that you understand the practicalities of the material or the question that they're actually asking and the answer that they're actually seeking. As in the years, just so that you can understand the historical context of these exams and why they've become a little bit more difficult of late, is that in the profession there was the profession was actually crying out that the standard of candidate attorney was decreasing, and this was posing a problem. And hence the LPC reacted by setting an appropriate standard, which I feel it's always a good thing to raise the standard of our profession. I've seen the quality of papers coming from some of my opponents, and all I can say is it is justified that we raise the bar, so to speak. But that being said, this is where the increased difficulty is coming from. So if you're able to show your examiner that you know the material, and even if you fail and you apply for a remark, you are likely to get the necessary marks to pass on having been granted the remark, which is great. At least you get a chance, at least you're able to pass the exam. Yes, some of you have been granted orals. Often my opinion is that when you've been granted an oral, it's maybe worthwhile to also have your paper remarked, as you're only missing a few percentile points. And hence you're close enough that when a person who actually understands law remarks the paper, they are able to find the marks and give you, and you don't need to attend to the oral. So that is my subjective view. That being said, I trust that you all know how to go about getting a remark. You apply in writing to the Provincial Council, you pay the necessary fee, and you wait for the remark. Now, I'd say that you should definitely attend to this as soon as possible and follow up once the week has lapsed if they haven't given you feedback. At the very least, this will be able to gauge whether or not during the examination you were on the right path, so that when you attend to the oral, you have that benefit. You might not necessarily get the paper or your exam script, but be that as it may, during the orals, there's a tendency to ask any and all questions pertaining to the subject matter, for instance, ethics. That is a bit of a mixed kettle of fish. They will ask anything and everything that was in the material, and there have been years where they've even asked aspects that weren't covered by the material, but a legal practitioner ought to have known. For instance, the Constitutional Court judgment that made the arrest and imprisonment of somebody for not paying money due in terms of a court order, that ruled that is unconstitutional. Most exam script preparers would expect you to have taken notes of that and also have to keep abreast of changes. So with that in mind, I just want to touch on something that you definitely want to keep abreast of changes in legislation. It helps with examination, with your exams and also orals, as you're able to show the examiners that you actually know what's going on in the subject matter. You are aware of the changes. This demonstrates competence, which these examinations are designed to determine and also weed out those who unfortunately do not meet the standard. Now, with that aside, I'd also like to touch on, and this is a tough topic for some of us who are perfectionists, myself included, and that is dealing with failing to pass your boards or a competency examination. Fortunately, I've passed all my boards. I'm an admitted attorney. That's proof of that. I'm also a notary, hence I do have experience. I've also written the conveyancing exam a few times. Unfortunately, that is an exam that has a bit of a reputation. But that being said, learning how to deal with failure is actually a great skill in the long term in this profession, because there will be times when you lose a case. There will be times where you thought your strategic approach in litigation was great, and unfortunately, it went completely pear-shaped on the day in question on which it was heard. Or your contract you felt was bulletproof, but somebody finds a loophole that you had no idea of. So, dealing with defeat and failure, I'm always of the opinion that we should not be scared of failing, because it's an opportunity to learn. I did something different. It's not something that the examiner was looking for. Okay, what is the examiner looking for? Now I'm developing a mindset. I'm trying to cater my future answers to a potential audience. Well, to a particular audience, my apologies. And hence, I'm already thinking differently and I'm gaining that skill. And as you make more mistakes, and which happens, we're all human, unfortunately. As you fail exams, you also learn things. Even if you're writing a particular exam for the second or third time, you might pick out a piece of knowledge, a piece of information that you did not remember previously, but you vaguely remembered it, and you found it so profound that it sticks with you for the rest of your life. And strangely enough, such lessons in case law and legal aspects, yes, they might be vague, yes, they might be very niche, but it's invaluable. And it also helps you develop an understanding, a greater understanding of the material. So you start thinking differently. For instance, I studied conveyancing a few times and written the exam a few times, but it's given me a very profound understanding of contract law, coincidentally. And there was a particular case that revolved around the contracts and the sale and purchase of immovable property. And because of that insight I had, I identified certain defects in the applicant's case that was so fatal that they, in the end, settled for 95% of what our client was asking. So this just goes to speaks to understanding the material and being able to, well, it speaks to having knowledge that was acquired elsewhere and be able to apply it elsewhere, which is what failure does teach you. So your answer might not be the answer to this question, but it could be an answer to a different question. And this comes back to my brother's remark, is understanding the question. Often the answer is in the question, strangely enough. I remember a few years ago, actually, when it was still the Law Society of the Northern Provinces, most people would look at the Afrikaans translation to get a hint as to what they were looking for. In some years, the Afrikaans translation gave hints of whether or not they were looking for a pleading or a notice or some other court process. That being said, I've waffled on long enough. I would very much like to open up the floor for anybody to put forward questions. Please feel free to unmute yourselves, or ask questions, or put it in the chat. And if you don't mind, can you put on your video and unmute yourself?
Yes.
Great stuff.
It looks like we have a bunch of shy people today.
Or they're rather deep thinkers.
But let's get that one.
No, it's something I picked up in court, is sometimes saying less is also saying more, because then the judge or magistrate has to focus only on what you've said. For instance, and this was a particular high moment of late, was when the magistrate ruled that my opponent's papers comprised completely and solely of hearsay. So yeah,
That speaks volumes to, as you said, the standard of attorneys which have been let through the ranks over the past, I could even say 10 years. Regrettably, you and I both fall into those ranks, but I'd like to believe that we try and elevate ourselves, and everyone that's trying to elevate their standard is doing the profession a good favor. I see we have a question from Shingiwe.
yes, regarding mistakes in the office. As a candidate attorney, I made a whole bunch of mistakes. As an attorney, I still make mistakes. I try to learn from them and then I try and improve on them. Often, and this is my big piece of advice, and if I would say that is anything that you take away from what I'm saying today, is if you made a mistake, speak to somebody who has a greater understanding of the subject matter and get advice. For instance, my candidate attorneys, they make a mistake. They come to me almost immediately, help. Sure, let's sort the problem. Forget about the blame. Let's sort the problem, solve the problem. So we're managing client, we're managing the matter, and the matter can proceed in its ordinary course without there being enormous fallout. And then we discuss the lessons and consequences after the fact. The fact that you've come to me, candidate attorney, already puts a nice green tick behind your name. You have the guts to tell me there's a problem. You rather sort out a solution rather than let it fester. I'm happy. I don't know about
I
you.
just want to compound Bruce's statement. It's a hell of a lot better to be honest about an issue or a mistake as opposed to try and lie and cover it up. It will come out and it will bite you in the tail. You will most likely end up being dismissed because of a mistake that you try to lie about and discover up. It speaks to dishonesty, and frankly, you will then not be able to be found as a credible person to be admitted. Honesty is your key. I see we have two more questions which are relatively similar. If you don't mind, I'll feed them.
By all means.
Okay, so first and foremost, do we treat the oral exams as new exams, or do we focus on the exam we recently wrote? That's a very difficult question to answer. My guide has always been the examiners will sit with your old exam paper beforehand, and they will determine where your weak spots in that examination were. And they will focus their questions surrounding that aspect, whether it be the theory portion of civil procedure or a practical point of estates. You can never treat it as the same exam. You will fail. You must treat it as a new exam guided by the exam you just wrote. Then Elizabeth, I see you have also asked, how do we prepare for oral exams? This was a topic I covered earlier, but I'll just briefly refresh again. Do not throw your paper away once you've written it. To prepare for an oral exam, take that same exam paper, go through it as you did with your old exam papers, prepare on the old exam papers, prepare on the material which you had to have studied, speak to your colleagues if you do not have an understanding. As I said earlier, there are Zoom oral exams as well as in-person oral exams. Personally, I found in-person oral exams to be easier, as you are able to judge the examiner as well as the question in a more clinical and critical manner. To prepare for oral exams, you need to prepare to speak. It's literally an oral presentation of your thoughts. You must be able to, logically and succinctly summarize your points, similar to bullet point form of what your intended answer will be. Something very important is to consider the question carefully and critically, as well as the manner in which it is asked, because that gives you a hint on how to answer it. If you're uncertain, ask your examiner, you have asked X, Y, and Z. Do you want me to give an example as well, or case law supporting? Or would you like a brief, succinct answer of ABC? That gives you a very good idea on what they're also looking for. And a big part of preparation speak to the examiner beforehand and say, look, I'm not used to speaking when doing oral exams, or I'd like to just tell you I'm a bit nervous. This will break the ice. It is my experience that it breaks the ice, and it sets you off on a good tone. Please, when you go for your oral exams, whether you're doing it via Zoom or via in person, dress professionally as if you are going to court. It is technically a formal interview. It is an interview of your knowledge on a specific subject.
So I see we've got two questions. First one being, what are the chances of getting articles before completing your LLB? And how do you structure that kind of CV? The problem with that question, it's possible to secure articles once you've obtained your LLB. Unfortunately, you cannot enter into an agreement to perform your articles prior to being awarded your LLB. It's unfortunately how statute has been written. The Legal Practice Act is rather express in that sense. The Attorneys Act was a lot more flexible. That being said, what is useful and what you can do is say, okay, I'm going to get my LLB on this date. I understand I can't be given articles. However, on upon getting my degree, I would like to be able to hit the ground running. This signals to a prospective employer that you want to be operational the moment you're awarded your LLB and the moment your articles have been concluded and put in place. This tends to encourage employers to rather consider you rather than reject your CV out of hand. As to structuring your CV, I'd focus it around the basis that, in full disclosure, I don't have my LLB. I almost have it. I just want to hit the ground running on the day that I start my articles at your firm. For instance, our firm, we tend to like that because then you're able to be orientated. You're able to understand the systems and processes that we have in place. So the moment you got your LLB and you got your articles, great, you hit the ground running. You're already a productive member of the team. That's just my view. Ian?
Well, our times were a bit different. We could apply for a position before we got our LLB. I was appointed a month before I actually got my LLB, and I started work a month before. So that by the time I got my LLB and I concluded my articles, I was already familiar with the work ethic in the background, and I was immediately able to jump in and, as Bruce said, hit the ground running. So in that sense, I do agree with you. If you are applying for a job, just make it clear. Your expected end date is December 2022, whereafter you expect your results to be positive and you will obtain your LLB thereafter. Moving on to Carmel's question, at what point period during as a CA does one start learning how to draft documents or contracts? This is...
It depends.
Dependent on the firm you're at. At my firm, we were drafting within a week. Affidavits for the banks and documents. Contracts I started drafting within 6 months of starting my articles. It is highly dependent on the firm at which you article. A lot of firms out there focus on third-party agreements, third-party claims. And it's not to say that you don't draft agreements or affidavits during third-party claims. It's absolutely the contrary to that. You do more affidavit drafting and more contracting between the firm and your clients than what a standard firm would do. The only difference is it's less exposure to commercial type contracts and affidavits.
100% couldn't agree with you more, Ian. Also, and truth be told, how I often approach this question is if the candidate attorney shows a particular aptitude, I would definitely push the candidate to start drafting. So in your principal's mind or your supervisor's mind, it could be entirely dependent on whether or not they think you're ready. And maybe have that conversation and ask them, listen, how can I get to that point sooner? They might actually view it in a very good, from a very good perspective. This person is a go-getter. and instantly you've already demonstrated some value that you can present to the firm. Now I see a question, how soon do the remark results come out after the closing date? Well, the LPC says it's 1 week. That being said, and I'm not trying to speak ill of the LPC, I do expect some delays. There's always delays of some sort. They've got to attend moderation, or unfortunately, human society is not a perfect system, so there may be a delay. I've told other candidates, wait 2 weeks. Then you start chasing the LPC. Okay. And I see Elizabeth has posted a message. This is advice to prospective candidate attorneys: attend vocational work during your university days to enable yourself to learn prior to obtain a CA position. Couldn't agree more. I love that. It
Also fully agree with that submission.
Yes.
It allows you to gain so much more experience and allows you to focus your area of aptitude and focuses your ability to hone in on a type of firm that you would like to do your articles, or a specific type of advocates with whom you would like to do pupillage. You're going to weed out a lot, and you're going to get a lot further by doing vocational work, even if it's for 1 week during your university holidays. Sometimes it may be unpaid, sometimes it may be paid. Doing vocational work, even if it is unpaid, it saves you from a lifetime of being in a career trajectory which you do not enjoy. You're going to save yourself a lot of distress and depression.
And if I may, and I'm going to be careful with my words, this will also help you to find a suitable place or suitable firm for yourself in respect to the dispositions of people at that firm. I'm very hesitant to go deeper into that, but I've seen some candidate attorneys use internships almost to probe law firms to see whether or not there'd be a good mix and whether or not there would be some sort of incompatibility, if you will. So those internships are definitely your way in. They're definitely a foothold. Even if it's unpaid, it speaks volumes about your character and your willingness and your hunger for articles.
Even beyond what Bruce says, in the cutthroat environment in which we deal every day of gaining articles, your internships add to your CV, it adds to your reference strength, and it shows that you have a foothold on which you represent yourself as well as your capabilities. A 1 week period is not a lot to ask, but it shows a hell of a lot more than just, I went to university, I did nothing else.
Okay, guys, thank you for all your questions. I see we are running out of time, but thank you. Next, in 2 weeks' time, we will again be holding these sessions. It's going to be a regular thing. Feel free to submit any topics or questions that you'd like us to attend to. Also, the link for the Zoom session doesn't change. It's the same link all the time, every time. And thank you all for joining us. I do appreciate it, and I know my brother does.
Thank you very much, everyone, and we enjoy the engagement. It's very helpful and eye-opening to see what candidates are dealing with every single day in their lives. And as always, we strive to make your lives a bit easier.
Thank you all. Bye.
Goodbye.